We ask, why should the voters elect you judge?
Why should they elect me?
Yeah.
Because I believe that I bring the dual experience of having been a public defender and a district attorney. I believe I bring that experience to the courtroom. I don't believe that there are, my opponents certainly don't have that experience, and I also believe it's unique to, there's very few judges on the bench that have practiced on both sides as well. So I also have, with respect to one of my opponents, I believe we'd have a totally different perspective on what the role of a judge is. One of my opponents excuse me, gave an interview with, I believe it was the Bay Guardian, and he said that that he was going to be an activist judge and that he was going to be a troublemaker on the bench. And I believe that he either has a fundamental misunderstanding of the role of a judge, or he intends to make a fundamental assault on the role of the judge. A judge is...
Are you talking about Supervisor Sandoval?
I'm talking about Sandoval, that's correct.
Okay.
And it's also on his webpage. He says other things with respect to sunshine laws being applied to this branch of the government. And I think you go back to the Federalist Papers, Marbury versus Madison, and you understand that that's just simply not the role of a judge. The judge, my judicial philosophy is that judges are the guardian of our constitutional system. And the executive and the legislative branches make the law, but the judge's responsibility is to make sure that those laws don't offend our Constitution. So when you say I'm going to be an activist judge, in my opinion, you're going to be a troublemaker. In my opinion, what you're saying is I'm not going to be independent. I'm going to let my personal affiliations and my personal views affect what I do in the courtroom. And that's simply not what we ask of judges. That's not their role.
You mentioned the sunshine ordinance. Was his comment in respect to opening the court up to open government principles? Was that the context of the troublemaker remark?
I didn't hear the last part of what you said.
What was the context of the troublemaker remark? Was it about open government or sunshine principles?
The troublemaker remark is different than the open government. The troublemaker remark, I believe, came in the Bay Guardian interview, and at the end of the interview, I don't know if he got excited or something, but he just said, I'm going to be an activist judge, I'm going to be a troublemaker. And so that's, in my opinion, it's inconsistent with my judicial philosophy. Also, I believe in the forum the other night, he discussed the fact that other individuals had served in elective office and then gone onto the bench, and that's true. But they went through confirmation hearings, and if you review their confirmation hearings, all of them declared that in fact they'd be able to separate the work they did in the legislature, and they would be independent, and they would be impartial. And so essentially what we're doing here is a confirmation hearing, and the public is going to decide it. And so that's how I distinguish myself from him. I have a totally different judicial philosophy than Sandoval does. With respect to the judge,
Judge Mallen.
Judge Mallen, not Judge Mallen. With respect to the judge, the reason why I challenge Judge Mallen is it's well documented that he had some issues in the courtroom with respect to the district attorney's office, and also with respect to the sheriff's department.
I thought his issues were more with the public defender.
Excuse me,
with the
I'm sorry, with the public defender's office. Okay. Sorry. And so judicial demeanor, I believe, is an important quality of a judge. And I believe that a judge, obviously a judge expects that there should be respect for the bench, but I think respect should also flow from the bench. And I believe that that respect has to flow to the attorneys, but to the court staff as well. And not only because it it makes the court run more efficiently, but because common decency requires it. And so the issues that came up with the public defender's office were there were major issues, and so they were large enough that he was removed from the Hall of Justice and sent to civil court. And there were issues that came up with the sheriff's department that just, in my opinion, shouldn't happen in a courtroom. I think.
Going back to, you're talking about your experience as the public defender and the district attorney. Can you tell us how long you worked at each office, what your assignments, what your main assignments were, and exactly how having those two different perspectives, what that creates for you?
Okay. With respect to the two different perspectives, I think how it's assisted me is that when I look at a police report, I read it from both sides. And really, I look at a police report, I think, in the same way that, I'll use a basketball now, a basketball player sees the lane or a chess player sees the board and you see the next moves. When I read a police report, I know what the district attorney, what their bottom line is going to be. I know what the bottom line of my client's going to be. I know what the judge is going to do. And I know what jurors I need. If I'm going to take it to trial, I know who I know, what jurors I need. I know how to advise my client. I know how to pick out the detrimental facts. And I know how to be honest with my client and to explain those facts to him. And I think that comes as a result of having worked in both the district attorney and the public defender's office, and knowing the internal structure of both, and knowing with respect to a district attorney's office what is required from the top, and how far you can stretch a case. My experience in the district attorney's office, I went up to the preliminary hearing level, and I did probably 75 felony preliminary hearings at all levels, except homicide and rape. With respect to the public defender's office, I was in that office for almost 7 years, and I did all levels, and I had combined total of 25 trials, and of those 25 trials, 24 of those trials met my pretrial objective, and in the 25th trial, my client didn't take my advice, and we lost. And that goes back to what I said initially, that my success in trial is because I think